The following program is made possible in part by the Dayton Bar Association.
Good evening, and welcome to You and the Law. My name is Jeff Swillinger, and I'm your host this evening. This program is brought to you by Dayton Access Television, aka DATV, and the Dayton Bar Association, who underwrites this show. Tonight's program is a live call-in show, as are each of the shows past and present, and future, It also live streams, and you can watch it not only on your computer, but on various television stations. I would refer you to the datv.org website for those stations. Our guest tonight is Jesse Beasley, and our topic is Medicaid. What you don't know can hurt you. Jesse is a longtime attorney and specializing in Medicaid planning and matters related thereto. I know that he's called upon by many lawyers in the greater Dayton area and probably outside of Dayton for his expertise. We're very fortunate, and I'm very happy to have him here. I've known Jesse for a long time. So at this point, I just want to point out one or two other things for you, and then we'll get started. During the course of the program, you can call in, and as I said, and we'll try our best to take your calls. We may or may not get to everyone, but we'll do our best. Number two, during the course of the evening, there will be telephone numbers on the screen for the Dayton Bar Association, and particularly the Lawyer Referral Service Program. And it's important that I explain that that program is there to give people an opportunity for a very, very reduced sum to possibly get someone with expertise in a particular area who might advise them not only on this topic, but on other topics, some of which we've already covered in the last 7 shows thus far this season, and future topics. So with that, I'm going to turn to Mr. Beasley and say, Jesse, good evening and welcome.
Thank you, Jeff. Thanks for having me tonight.
It's our pleasure. It's our pleasure. It's good to see you again, my friend. Now, why don't we start with you giving our viewers a little bit of your background, and we'll listen and your certifications, and how maybe even how it is you came to do this kind of legal work.
Well, I've been in elder law just had my anniversary for 29 years. Okay. I am a solo practitioner. I am certified. As you know, the Ohio Supreme Court recognizes specialists in certain areas of the law. I'm certified by the National Elder Law Foundation, which is endorsed by the ABA and certified by the Ohio State Bar Association, both of which are recognized by the Supreme Court.
Oh, very good, very good. And your office is in Montgomery County?
That's correct.
And you're a few miles north of Dayton. We were discussing that earlier off camera. Why don't we get right to the subject matter? I'm hopeful that we'll have some good callers tonight, and we have a lot of subject to cover. So why don't we start with talking about what the difference is between Medicaid and Medicare?
Well,
there are a lot of differences.
Well, there are a lot of differences, but it's easy to confuse them because if you're like me, you always hear about Medicare and Medicaid in the same sentence. And it's confusing because they're very different from each other. Medicare is the federal health insurance program. I think of it as a major medical coverage, with the United States being the insurance company. Okay. It's like any other major medical coverage. It has premiums, it has deductibles, it has copays. It only covers certain things within its policy coverage. It is generally a federal program. And for that reason, for us, for the consumer, it means it's the same in every state. And it's supposed to be consistent throughout the country so that Your Medicare coverage in Ohio would be the same if you wintered in Florida or Texas or anywhere else. Medicaid is pretty much the opposite. Medicaid is not health insurance at all. Medicaid is designed as a safety net to catch you when you run out of the ability to pay for your own care. So it is there instead of becoming homeless. If you run out of money paying for your health care, it used to be that you were pretty much at the mercy of your family or church or whatever charity you could convince to help you survive. Medicaid was passed to change that so that the federal government and the state government are there to step in and catch you from going into homelessness. A big difference is that Medicaid, a lot of state money goes into Medicaid, so the federal government allows each state a lot of leeway in how it runs Medicaid. The consequence to you and me is that Medicaid's different in Ohio than it is in Florida or North Carolina or California. Each state's program within broad federal parameters is interpreted differently. So what we say tonight is concerning Ohio Medicaid, if you move to Indiana, it may be different.
Well, I think that's very important. It's my understanding that we have folks viewing the show from outside of Ohio on occasion, and I think that's very important that you emphasize that point. And again, one theme underlying all of our programs is that this is general advice, and when you have a legal issue, legal problem, it's best to seek out individual legal advice from your own attorney, if at all possible. So we'll talk about that a little later, a little bit more. But please go on. So we're here to talk about Medicaid. Jesse's told you about that in terms of its overall difference between Medicaid and Medicare, the federal and state aspects of this. Insurance is a safety net. Let's talk about what types of care are covered when we're talking about Medicaid, Jesse.
Sure. Well, again, because of the state specificity, it's going to vary from state to state. Ohio traditionally had only covered nursing facility care, not covering home care, not covering assisted living. You had to actually be in a nursing facility in order to have Medicaid assist you. The consequence was that if we had, for years, a number of folks who were in assisted living and doing well there, but ran out of money. Since there was no one else to pay, they would end up in nursing facility care when they didn't really need that intense a care. Not a good situation.
Yeah.
So what has happened over the years is that Ohio has expanded the type of coverage or the type of care that's covered, but each one's a little different.
Okay, and each one we're talking about, each one being assisted living, nursing facilities, and home care.
Right.
Okay.
The basic concept, because that's what Ohio's been used to, is the nursing facility care, and I'd like to focus on that tonight because that's the easiest to explain.
Okay.
The others are variants on that model.
Okay.
So they're slightly different, and you have to look at the exact regulations in regard to that particular care.
That's fine. And as you focus on that, if you need to move back and forth and talk about the others or compare them, just feel free.
Okay, good.
Okay, go ahead.
Good. Well, we do have several types of Medicaid depending on what type of care you're asking the state to pay for. Okay. There's basic Medicaid, which really is like having Medicaid as your health care insurance. And you literally get an insurance card.
Okay.
That type of Medicaid is really for people who are living in the community and have, and this is consistent throughout Medicaid, you have to have low enough income and low enough resources to qualify.
And resources, just generally, what does that mean in addition to income?
Well, Medicaid calls assets resources. And it really is overly inclusive. A lot of Medicaid is what I think of as involving negative definitions. For example, with resources, they say resources are everything you own in this world that's not income and that is not specifically excluded by a Medicaid regulation. So they start with encompassing the whole and leave it up to us, the consumer, to take a particular asset out of being considered available to pay for your care if there's a regulation that justifies that.
Okay. And as I imagine you'll get to later, that's where part of the rub comes sometimes when people have one understanding or believe they can do something relative to an asset, and the Medicaid folks say, no, that's not right. And again, our topic tonight, what you don't know can hurt you. Sometimes if you act without knowledge, you can end up in a situation of being ineligible for the Medicaid. Is that right?
That's right. Okay. It's fairly easy to stub your toe because Medicaid's system is, in large part, modifications to the system over the years. Medicare in its present form started in 1972. So there have been a lot of experiences with Medicaid and, frankly, with what people have done to try to get around Medicaid. So we have a lot of fixes or coverages to loopholes, if you will. Okay. And instead of being a linear explanation of how the program works, you have to make your way through all of the different fixes of those loopholes.
Okay. So adjustments as questions come up or other matters evolve, and those fixes, you're going to be talking about those, so please.
The thing that's consistent through most, and I just thought of one exception to what I just said, to most Medicaid programs, most of them you have to have the low enough income and the low enough resources, and it's very important to keep those separate because they're different. They treat them differently. But there's one program called Modified Adjusted Gross Income, MAGI. They call it MAGI Medicaid.
Okay.
Okay? It's not the gift of the Magi, but it is spelled the same. That program started in August of 2016. That's the so-called expanded Medicaid. You may remember was in the papers and in the news a lot when then Governor Kasich and the legislature had a dispute about whether to expand or not. Well, we have some expansion. And the important thing about Magi Medicaid is it doesn't have the income and resource test. It only has an income test. So if you have low enough income and have $1 million in the bank, you may qualify for Magi Medicaid. It's the one very different type of Medicaid that is confusing to most of us who are used to the traditional Medicaid, but it's also very confusing to the consumer because when somebody at the hospital tells you you're approved for Medicaid, they don't explain which kind of Medicaid you're on, and most of us don't know. So it's rather confusing to know what you can do with your assets, but in addition to that, it's confusing to know what's allowed and what isn't and why, because you're not sure which category you fit in.
Now, you're going to talk, I imagine, about how you go about analyzing that issue. But my question right now is that change in the law retroactive, or is that only for new Medicaid applicants as of when the law became effective?
It's only prospective for people who apply after the effective date of that was August 1 of 2016.
Okay.
So anyone applying today, and Medicaid is supposed to do this, and they do a pretty good job of it, they're supposed to run you through any type of Medicaid you might be eligible for, and then to approve you for whichever one is the most beneficial for you. That is fine, but to the consumer, Medicaid is Medicaid, and it's not as easy to understand, even if you've been on Medicaid for years and years. I have clients all the time who come in and say, I'm on Medicaid. I say, which kind? Well, I don't know. And we have to explore that with the caseworker to make sure we understand what we can and cannot do.
Now, for those already on Medicaid prior to that change in the law, remember where you were, we'll get back right to that in a moment, who were on it, is it a matter of self-help? Is the laws changed that you have to notify someone that you want a broader analysis of your Medicaid and what you're eligible for or not? Or is that something that the government representatives are going to do for you? Or some combination?
It's sort of a combination. If you have what they call a change in circumstances, if you're a Medicaid recipient, you have an affirmative obligation to report that to your caseworker. Okay, and that's a rather short deadline for reporting that, because that could change your benefits, could eliminate your benefits. And in addition to that, there is a review every year to make sure you haven't won the lottery or some other disqualifying event, or if things have changed, to make sure you're not more eligible for more benefits.
Okay, okay. And that's particularly so since that particular date in 2016, when in Ohio at least, the law changed.
Well, that's correct. And Ohio, to make a long story short, we used to be stricter than SSI. SSI is the needs-based part of Social Security disability.
Okay.
Now we're essentially the same as most states on following the SSI guidelines.
I see. Okay. All right. All right. Now, why don't we move then, if you feel you've covered that, why don't we move to talking about the types of Medicaid waivers, for instance, that come into play, institutional resource assessment, this type of thing, if that's where we are in the conversation.
Well, we already mentioned the basic Medicaid, using the card as your insurance, and we've talked a little bit about the Magi Medicaid.
Right.
The waivers are what they call home and community-based services for people in the community who are don't need to be in a nursing facility. And one way to think about the waivers is, if it weren't for this waiver, you might need nursing home care. So they're designed in an altruistic way to try to prevent you from having to go into permanent long-term care in an institutional setting. There are a lot of waivers in Ohio. One of them, well, probably the most popular one, is called Passport, which is designed to deliver to you at home nursing home type of services while you stay at home.
Now, let's step back for a moment. I'm a little confused. Just want to make sure this is clear. These waivers come about when someone might be eligible under this waiver to not go into assisted living. And there might be a waiver that would allow them to use Passport or whatever the vehicle is for home care. That's one example of how the waiver works.
That's one example, but let me clarify a little bit, because let me take you back to the past in Ohio, where we only covered nursing facility care.
Okay.
Well, in order to try and cover assisted living, even on a trial basis, which is where we are today, the state had to go to the federal government and say, will you waive a certain requirement under Medicaid? That's why they call them waivers. And the state has to submit a waiver plan to the federal government on how it's going to run the program. One of the things that's commonly waived in a trial program is uniformity throughout the state. A lot of times, if they're doing a trial program, they'll do it in 2 or 3 counties to see how it works first. Well, Medicaid's supposed to be uniform, so the federal government has to waive that uniformity requirement in order to approve the program. The assisted living coverage we have today is under a waiver. The home care that we have today is under a waiver.
Well, a waiver from the base nursing facility
That's correct.
trajectory that existed before.
That's correct.
Okay.
Because, again, in each of the waivers, those 2 in particular, you have to have or need something akin to nursing facility care, but you don't want to go to an institution. So the waiver, in essence, keeps you out, lets you stay at home.
And I guess as a brief reminder, obviously you talk about this when it's relevant to the client, for instance, it's coming to you, but someone could already be on Medicaid and may be seeking a waiver, or that might be something that they're going to start with. Maybe make that part of their initial application. Is that right?
Yes.
Okay. Okay, depending upon what their needs are.
That's right. That's right. Most of us, I think, most of us would prefer to be at home.
Okay.
So a lot of times we'll explore if you're experiencing failing health, what are your needs? Are they at a level that we could handle that at home? If you need 24-hour-a-day, 7-day-a-week care, the Medicaid program, the waiver program, is not sufficiently funded to move somebody into your home to live with you. So if you need 24/7, you're going to still have to go into that nursing facility setting. But if you don't need 24/7, maybe there's an interim measure that we can take and deliver some services to you at home.
With the idea either you can take care of yourself a certain number of hours a day or have a family member. Okay, now we have a caller online. Good evening, caller.
Good evening, Mr. Swillinger.
Good evening. This is an esteemed caller. I recognize the voice. Please.
So I couldn't get by.
No, you couldn't get by. Good evening.
First,
Mr. Monta,
a question, though.
how can we help you?
I would like to congratulate you on doing a full year of You and the Law successfully, as I see it.
Thank you.
And secondly, congratulations on your second grandchild born last week.
Thank you. Thank you. Appreciate that, Michael. Thank you for calling.
You're welcome. And enjoying the program tonight.
We have a very, very good speaker, as we have for each of our other programs. Do you have a question?
I do have a question.
Oh, good.
And, this comes up sometimes in casual conversation with people who think that they may be going into medical care. They do have assets. They might be married. They might have children. A house that they've paid for, and maybe some small bank accounts. And wondering if they can preserve those assets for their beneficiaries' children, or if they don't have any, does the wife have to use up her assets, say, if for the husband's care, or vice versa?
Well, that's a good lead-in into where we're going with this. But you're correct. Most of us, and every parent I've ever talked to has said, when my time comes, I want my wealth to pass to my children. Medicaid doesn't want that to happen because Medicaid is designed to pay only if you can't afford to pay. So if you give everything to other family members and then plead poverty, if you could do that, everyone would do that. And Medicaid would go even more broke than it already is. So a large portion of Medicaid's rules is devoted to preventing you from being able to do that. There are some exceptions, and that's really where the Medicaid planning comes in.
Now, Michael, does that generally answer your question? Because I believe we're going to get into that a little further in just a few minutes on our outline of topics that Jesse has been kind to put together. But,
Well,
or do you want to ask a follow-up question or two?
no,
on that?
as a follow-up, I'm wondering if there, and this is generally asked of me, whether there's a time limit, say like if you gave away your house to your children 10 years ago, or whether it's 2 weeks ago, whether it makes a difference.
It does. The form of the plan that Medicaid has instituted, and this is on a national level, is whenever you apply for Medicaid, you're under oath when you apply, so you don't want to commit perjury. You are asked, have you or your spouse given away anything in the last 5 years? They look back 5 years, and they call it a look-back period. Any gift made in that look-back period, that 5 years, is automatically presumed to be done for Medicaid reasons. And if you don't prove them incorrect, you're disqualified from Medicaid because you gave away something that could have been used to pay for your care or your spouse's care. If you gave away $1 million 6 years ago, they don't care. Has no effect. Now that look-back period, that 5 years, used to be 3, and the threat is always they may make it longer. And I've heard numerous rumors that they already have, but they have not. It's 5 years.
From starting when?
Well, that's the trick. There are a lot of confusing timing issues in Medicaid. It's 5 years from the first time. Two things are true. One is you need the type of care Medicaid covers. For tonight, we'll call it nursing home care. But number two is you first apply for Medicaid. So if you have given away $1 million 59 months ago, and you're in a nursing home, and the social worker comes up very well-meaning and says, here, sign this application for Medicaid, we'll go see where you stand, it can't hurt. She is completely wrong, and she is going to cost you over $1 million. Because if you wait another month before you apply for Medicaid, your $1 million that you gave to your kids is free and clear, and you might be eligible for Medicaid now. But if you apply too early, you literally shoot yourself in both feet.
Relative to this look-back rule.
That's correct.
And then just to play on that, if at 59 months in that scenario you apply, and you've already been receiving nursing home care, kind of that two-pronged test you just suggested, and you gave away $1 million 5 years ago in one day, then we explained just briefly what that means. You said you lose $1 million, but what you really lose immediately is your eligibility going forward for Medicaid.
Well, it's a little more complicated than that because of some planning techniques that people have attempted.
I should have said, do you lose
You do.
your eligibility?
You lose eligibility for a calculated period of time. The calculation has changed, and the beginning of the penalty has changed because of some what should I say, innovative strategies that some lawyers have come up with. Medicaid, both on the state level and on the federal level, have changed the law to prevent those type of strategies from working.
Okay.
Okay?
Now, were you planning to talk about any of that later on?
Yes.
Okay.
Did I answer your question, Mike?
Oh yeah. I do have one other corollary,
Okay.
if you don't mind me asking more.
Oh, no, not at all. It's just all helpful. I think you're just prescient, if that's the right word here, asking these questions, anticipating what we're going to be talking about. But
Well,
let's do so while you're on the phone, because we may not get to those issues as the clock keeps ticking. Go ahead, please.
Often we run into folks elderly or getting elderly, one or the other, with modest assets, but not down to the level for Medicaid eligibility, and panic sets in with the spouse who does not have the medical emergency, and they're thinking, well, maybe we should split our assets up or get a divorce or something like that, and then the non-medical spouse can preserve those assets.
Are you asking what happens, for instance, if someone comes into Jesse's office with those kind of questions? What might he tell them?
Exactly.
Well, we need to back it up a little bit, because as we were saying earlier, there are income qualifications and then there are resource qualifications. One of the things that's important to keep in mind is that those are treated very differently. With income is exactly what you would think it is. It's Social Security, it's private pension, it's an annuity payment, it's whatever you receive on a regular periodic basis. With income, they ask, whose income is it? A husband's is his, a wife's is hers. And depending on who is in care, they only look at the income of the so-called institutionalized spouse. The income of the community spouse, the spouse living at home, doesn't count. And we'll come back to that later on. With resources, they don't care whose name it's in. If the husband owns it, it gets counted. If the wife owns it, it gets counted. If it's jointly owned, it gets counted. If it's in a revocable trust, it gets counted. Because the theory is, and this is true under Ohio law as well, as it is in most states, if your spouse can't pay for his or her health care, you're obligated to do that. So Medicaid looks at the assets of either spouse as being available for both spouses. And what they do is they look at the total countable assets on the first day that either one of them went into care and stayed there for 30 consecutive days. A lot of people call that date the snapshot date, because they take a photograph, if you will, of your assets as of that date, even if you don't apply for Medicaid for another year after that. They're supposed to go back and say, what did you own on that date? Okay? They artificially allocate the assets between the two, and the assets that are attributed to the institutionalized spouse have to be reduced below $2,000 before Medicaid will pay. That's the magic number, is $2,000 for a single person. For example, an unmarried person cannot have more than $2,000 in countable assets. So if you have not experienced the snapshot date and you're married, then that raises another timing issue. If you're single, there's no such thing as a snapshot date because there's no spouse. And the issue becomes, what do you do to get to $2,000? And that, again, is where the planning comes in.
And there are terms such as spending down your assets to get there, is that right?
That's what a lot of people call it. We used to have an unrelated income issue called spend down Medicaid, and a lot of people misunderstood that because the popular term is, I have too many assets, I have to spend them down. Okay. That's what a lot of people think of it as, but it tends to be confusing. So
that's a colloquial term, that's
Yes.
not a term that Medicaid uses?
That's right, yeah.
Okay.
But the point is, what can you do with it? You can always spend it on goods or services for you or your spouse, because it doesn't matter whether your assets are all in your spouse's name or all in your name, they're exactly the same. If you spend it on goods or services for you or your spouse, as long as you don't give it away, Medicaid has no objection.
Okay.
Now, you have to be careful because, as I was saying earlier, there are Medicaid is full of negative definitions. Remember, everything you own in this world counts unless there's a Medicaid regulation that says, in your circumstance, this doesn't count. For a single person, or for most of us, the list of things that don't count is real short. If you live in your home doesn't count because we're not going to make you homeless to pay for your care.
Does it matter how it's owned, or how it's held, how it's titled?
Yes.
Okay.
Let me go through this
Okay.
list real quickly
Go ahead.
because it's short.
Okay.
One automobile doesn't count. If you have more than one, it doesn't mean you have to sell it. It just means it counts in that calculation they do on the snapshot date.
Do they take the more or less expensive one?
They let you, actually, they're generous. This is one of the few times they're generous to the consumer. They let you exempt the most valuable vehicle you have.
Based on its fair market value, I guess.
Yes.
Okay.
Okay. Household goods and personal effects don't count. You don't have to sell your television, your refrigerator, or your furniture. Personal effects we usually think of as clothing or jewelry. They list musical instruments. If I went into a nursing home, my wife would not have to sell her piano. She'll be glad to hear that. And what they call pre-need funeral and burial expenses don't count because it's an expense we're all going to have. And they encourage people to plan ahead because if they go on Medicaid, they're not going to have a lot of money left to cover those expenses.
So they encourage them to prepay those expenses?
Yes, that's correct. That's it. Everything else, pretty much, counts as being available to pay for your care. Okay? Now, some assets, because of their peculiar status, have specialized rules on, for example, how Medicaid treats annuities. But the basic concept is only specifically exempted assets are exempted. The others are countable. And their view of the world is anything that you or your spouse owns that you can turn into cash is available to pay for either one of your care.
I don't want to go too much on a tangent, but I would imagine pensions, either private pensions or public pensions, state teachers or public employee pensions, whether they're covered by state law, federal law, or some aspects, both. Is that a different set of rules there also?
There are, and it's much more complicated than we're going to cover tonight, but in general, the fact that you have a retirement fund doesn't protect it. There's one exception, if you're working and you have to quit your job to access your retirement fund, they don't make you quit your job because they want you to keep working. But the general concept is, could you go get it? And the answer is typically yes, whether it's an IRA or 401k or whatever. They don't care that it's going to cost you taxes. They just care, could you go get it? So if you could, the general answer is yes, it counts. And it doesn't count to, they don't deduct the taxes in the amount that they count it as, because their view of the world is, we don't know if you're ever going to pay the taxes until you do. So if I have $100,000 in an IRA, and it's going to cost me $25,000 to go pull it out of the IRA, they still count it as $100,000
Of countable assets.
of countable assets. Now, if I go and pull it out of the IRA and prepay my taxes before they're due, they'll count it as 75 because I've already paid the taxes. But if I haven't paid them yet, it's still 100. Which is, and Mike, I know you didn't specifically ask this, but is another concept you need to keep in mind. They don't net out liabilities and indebtedness. They simply look at, what do you have, and we don't care what you owe. So if you have a second home with a mortgage on it, that's worth the fair market value of the property.
I keep wanting to say there are a lot of presumptions here in favor of the government, some of which are rebuttable.
Yes, they're all rebuttable, but it's you're arguing uphill.
You're arguing uphill, and the burden is on you, the applicant's family member, to raise those issues. And I'm sure that our listeners, our viewers, I know my head is swimming a little bit with all this information. I'm sure there are those out there who may have some of the same feelings and thoughts. This is a good time to just briefly segue about how important it is, therefore, to do some planning. Because this is where, just like the topic tonight, Medicaid, what you don't know can hurt you. You can see that there are a lot of things that you need to be advised about, a lot of matters, a lot of issues that you need to be advised about before you take that big step and make that application, if at all possible. I'm sure that there are many situations where things happen very quickly and people can't always do that planning. And that makes it even more difficult. And I'm sure when people come to you and they're very upset, they're very distraught because of something's happened, and they say, what can we do? And we have to do it now. And sometimes you can help them, and sometimes you just have to explain in the course of helping them that there's only so much you can do. And that must be very difficult for them, and even for you too.
Well, it is, and just like any other area of the law, planning ahead of time is always advisable, rather than being in a crisis and having to react to that crisis. Most of us, I think it's true with many areas of estate planning, most of us don't want to think of the possibility of needing to live in a nursing home, or needing some assistance to be able to eat or bathe or go to the bathroom, or any of the things we all take for granted. If that happens, though, and it certainly doesn't happen to everybody. I'm not trying to portray that, but the consequences can be so devastating that perfect estate plans can be totally thrown asunder if you need long-term care. And if you haven't included that in the possibility of your needs, you may find out the hard way that that's something you should have considered.
Okay. Michael, I'm going to suggest that we go back to our format right now, unless there's some burning question that remains. We have no other callers online, but we have about 10 minutes and counting left in the show, and we have a number of topics. I'm not sure we're going to get through all of them, although I think we've touched upon some of them already by your good questions. How's that? Does that work for you? Okay.
I think we bored him enough to get off the line.
Well, I think informed him, or his head is spinning also. Okay, thanks for calling in. Jesse, in our outline, we were talking about about to talk about, I think, resource eligibility, or maybe finish up on the income eligibility. I'm going to leave it up to you as to what you feel we should try our best in the next 8 to 10 minutes to get in front of everyone, and I'll just let you talk, no questions, and maybe you'll be kind enough to come back in the new year. It's a good time to say this is our last show for the 2018-2019 season. We'll be back in the fall in October, but get you back here and maybe update whatever's changed, and
I'd be glad to.
complete the topic. But why don't you go ahead?
Well, we've touched on a lot of these issues, but just for clarification's sake,
Okay.
and just to comment about the head swimming issue, I tell every family I meet with, if this system makes sense to you, you probably have it wrong, because it's not a logical system. It is quite literally the ultimate in red tape and bureaucratic programs. So you have to think in the way that Medicaid does in order for it to be semi-logical. Again, I want to emphasize that the income piece of it is totally separate, and one of the strategies is to try to use your assets to increase the income of the community spouse. For largely historical reasons, the income of the wife in most marriages, the retirement income, is lower than that of the husband. And for whatever reason, the medical reason, the health of men fails before women's. So the most common situation, if we have a married couple separated by institutionalization, is we have the spouse with a higher income in the nursing home, where the spouse with the lower income is at home and she has a smaller income. So one of the strategies is to try to increase her income by use of an annuity or some other methodology to shift that income to her.
And that's part of the pre-planning long before you file an application.
That's correct.
So I said I wouldn't interrupt, but
No, you're
that
fine.
requires you to take a step. If something is convince you that maybe you need to do this, even though you don't know that's going to happen down the road.
Well, that's right. And annuities are a little tricky because really what you're doing with annuities is you're taking a bag of money and you're giving it to this annuity company in exchange for a contractual promise to pay periodic payments for a set period of time or for the rest of your life or what have you. But what you're doing under the Medicaid rules is you're taking a resource and turning it into income,
Yes.
and income of the community spouse just doesn't count. Well, you could do that with any amount of money, and so as you might expect, Medicaid does not like that strategy. So there have been, at least since I started in 1990, numerous ways that Medicaid has tried to attack annuities. And it is a good strategy if it works, but people have to realize that it's a high-risk strategy. The reason I don't favor them all that much is that if you annuitize that contract with the annuity company and it doesn't work, they're not going to give you your money back. You've agreed with the annuity company to take the stream of income instead of the bag of money.
And when you say it doesn't work, that means that it becomes treatable income.
If Medicaid says that you gave away something because you didn't get fair market value,
Right.
or we don't like the way you annuitized it, or any number of
Then
different
it's
things.
income to you, and that can affect your eligibility for
That's
Medicaid.
correct. That's correct.
Okay. Please go on.
One thing that's not on our outline that I do want to mention is if Medicaid does pay for your care and you qualify for those benefits, one of the other planning strategies that you also need to consider, because it's mandatory that the states do this, is Medicaid if Medicaid pays for my nursing home care, when I die, we're all going to die. When I die, Medicaid can come back against my estate to recoup what it paid for me. Well, you can plan around that because the biggest item that we don't count, remember the four fingers, is the home. Well, you don't want Medicaid to take the home and have your spouse and children homeless. So that's another scenario that you can plan around.
The four fingers being the home, the auto, the household goods, personal effects.
Correct.
And the pre-need funeral and burial,
Yes, sir.
just for our viewers. Okay.
That's right.
Okay. Please go on.
Okay. In planning, as you were saying, pre-planning is best. If, and I'll go back to Mike's example, you have a family with modest means and you're looking at planning, well, there are a lot of timing issues involved. If it's a married couple and we're looking at one of them needing care, has the snapshot date occurred? Because that's very, very important. If we had $100,000 in our countable asset pool on the snapshot date, and the community spouse gets half of that, $50,000, if the snapshot date has not yet occurred and they have $100,000, and you go add an addition to your house and shrink the pot to $70,000, then the snapshot date happens. Well, you have just taken away $20,000 from your community spouse because now she gets half of 70, not half of 100. If you waited until after the snapshot date, she would get 50, and then when you spent the $30,000 on the home improvement, that would be your spend down. So you have to watch the significance of the timing of issues, not in the real world, but in the Medicaid world, because it's quite different.
Okay. Of course, the real world is what happens when you're doing planning, right?
Well, the real world is what we have to deal with, of course, and a lot of times, what you can do for Medicaid planning, you may not want to do for very real world reasons. Now, one of the strategies is always you can invest in things that don't count. So you can sell your Buick and go buy a Lamborghini because one automobile doesn't count. Doesn't matter whether it's a $20,000 vehicle or a $120,000 vehicle. One automobile doesn't count. But do you want to pay insurance on a Lamborghini? Do you want to pay for the repair to that inch dent that went into the fender?
And is there, when you talk about post-death recoupment, as long as that's titled in your non-applicant's spouse's name, if that car gets sold, at or about the time of death, let's say the surviving spouse says, okay, we just have a minute left. Well, we want to sell that. Could that then become recouped by the government?
The answer is complicated.
Yeah, okay. Well,
Okay. Let me put it this way.
plan on those kinds
Plan
of issues.
ahead for that. Typically, and Medicaid actually usually suggests this, but it is a wise thing. Once one spouse qualifies for Medicaid, you want to get the assets out of his or her name and into the name of the other community spouse. That's a wise thing for Medicaid eligibility, but it's also a wise thing for Medicaid estate recovery.
Okay. I think we've just got seconds left. I want to thank you for being here this evening. I think we've got more material left to cover that we haven't been able to this evening, but I really appreciate all this. I think the importance of planning whenever possible has been emphasized over and over again. Jesse, I thank you very much, and I'm just happy that there are folks like you out there who have chosen this area of the law in which to specialize, in which to help people.
Well, Jeff, thank you very much for having me. And again, congratulations on your new grandchild.